Having said those things, I propose to inform the parties of a number of considerations that they may wish to comment upon. The first is, conformably with centuries-old practice, if in an urgent circumstance it is considered necessary in the interests of the administration of justice to permit a party to make an application in effect before a formal originating process has been filed and served, the court can, upon appropriate undertakings, entertain an application in advance of the proceeding being formally initiated upon an undertaking to file and serve the originating process in formal terms as soon as reasonably possible. Allied to that well-established practice, and as might seem to be the case here, in appropriate cases, the court may also be prepared to accept an undertaking from the parties or one or other of them to file and serve an affidavit which exhibits the material documents at the soonest opportunity. Applied in this case, that would seem to me to require undertakings of that kind, including for an affidavit to be filed to which is exhibited a copy of the decision which I understand was made late today, together with a copy of the reasons upon which the decision was made. Now, Mr. Lloyd, you may wish to assist me in this way, and that whether you wish to or not is entirely a matter for you. I wish to make that clear. But I have two documents. One is a statement of reasons. The other, which I'm concerned to draw to your attention, is a document which is entitled on government letterhead, if that's appropriate description, a submission. And on page 7, without saying more, can I draw to your attention paragraphs 39 and 40 of that document, if you have it at hand? Do you?
I think so, yes. Does it start under the heading sensitivities?
Yes, indeed. I don't want to read it. My question, of course, I should, for the sake of clarity, confirm that the appearance that you've announced with your learned juniors is an appearance on behalf of the Minister for Immigration, Citizenship, Migrant Services and Multicultural Affairs. Do I understand that correctly?
Yes, Your Honour, you do.
Thank you. Having drawn those matters to your attention, Mr. Lloyd, can I draw to the party's attention Section 67 of the Federal Circuit and Family Court of Australia Act 2021. You don't need to call it up. I will summarise the matters which are of immediate concern to me. They establish, as is established in most Australian courts and relevantly this court, an overarching purpose of the practice and procedure provisions which are to be applied by all parties and their lawyers and the court. In summary, the overarching purpose is to facilitate the just resolution of disputes, and I would emphasise the succeeding sub-paragraphs, according to law, as quickly, inexpensively and efficiently as possible. and to secure the disposal of proceedings in a timely manner. Now, in this proceeding, it appears from the submission that's been provided to me that at least one, if not more than one, important documents from what I might conveniently call the first proceeding have been supplied to your client, Mr. Lloyd, for the purpose of consideration of the exercise of power under section 113C. That becomes important for a matter that I wish to raise with the parties, but in an endeavour to pay regard to the at least objective of securing the quick, inexpensive and efficient final determination of this proceeding, we have already had submissions on Monday which recognised fully the at least not uncommon experience in this jurisdiction of a succession of appeals. I raised the issue with the parties in that way for this reason. The court is conferred power to consider the exercise of its discretion, of its own initiative, to transfer a proceeding from this court to the Federal Court of Australia. When it does so, by force of section 153, subsection 5, the court may make such orders as it considers necessary, pending the order transferring the proceeding being confirmed by the Federal Court. That is to say, while I have, it seems, an unappealable power to transfer a proceeding from this to another court, it's qualified by the requirement in subsection 153(4) that the Federal Court of Australia confirms the order I make pursuant to section 32 AD of the Federal Court of Australia Act 1976. Now, it is very clear that it is not for me to suggest to any other court how they might efficiently conduct the business of the court. But I am firmly of the view that the following matters ought to be decided now, and that any question of directions as to the future conduct of any further proceeding are matters which the parties, if they're so advised, would take up with the Federal Court once the administrative arrangements dealt with between the registries of those courts can secure the allocation of the proceeding to a docket of another judge. And I think it is uncontroversial at this time of year that cases of this kind fall to duty judges outside of the legal year, or to judges who are asked to take up the cudgels when parties need urgent attention. Now, it seems to me necessary, upon the indications that I have given, to address a number of issues which could be dealt with either by way of undertaking or by way of court order. The first of those is, as occurred effectively by consent on the 6th of January 2022, the parties were able to agree in orders that would preserve the status quo pending a final hearing last Monday on the 10th of January. And I regarded at that time, as I still do, the conduct of the parties and their lawyers at that time commendably as being completely consistent with their overarching obligations to the court and to each other. Translated into practical terms, the sort of status quo orders that may be needed or could be resolved by undertaking would include the following, at least topics. One would be to grant a brief interim injunction. I had in mind until 4 p.m. on Saturday, 15 January 2022, or further order, or unless the applicant made a written request of the respondent for his removal from Australia, to effectively restrain otherwise any step for his immediate removal. That's issue one. Issue two, which I may need some assistance about, and the availability of power as a matter of real concern to me, is, at least upon my limited understanding of the matter at this stage, there is in prospect that the applicant has been invited to an interview tomorrow. So what may flow from that upon the decision having been made today to cancel the visa is that other provisions of the Act would be engaged, requiring, in effect, the applicant's being taken into custody and his being detained in order that the minister could perform the statutory obligation which is imposed to remove the applicant as soon as reasonably possible from Australia. Now, that is an issue where I am concerned about what is actually open to this court and what is, more importantly, not open as a matter of power. Now, the three other matters, are as follows. Transfer, pursuant to Section 153 of the Federal Circuit and Family Court of Australia Act. Next is a direction that the parties and each of them forthwith do all things and take all steps as may be reasonably necessary to make application to seek confirmation of the transfer of the proceeding pursuant to Section 32 AD 1 of the Federal Court of Australia Act 1976. Next, subject to a matter that I need to address, I've referred earlier to undertakings, and I had in contemplation that it would be sufficient compliance with an undertaking to file and serve an originating application and any supporting affidavit by 5 p.m. on Saturday, 15 January 2022. Conformably with the earlier order, that should come back perhaps to 4 p.m. The last thing would be the reservation of the parties' costs. Now, having raised those matters, the next issue that I need to deal with is that I will be publishing, and at some stage I will be publishing effectively extempore reasons which explain the position which has obtained in this court up to 9 p.m. tonight. I think, gentlemen, and indeed I hold the view quite firmly, you will all be well familiar with the practice of superior courts to provide a non-tendentious summary for persons other than the parties to the proceeding in order that they might properly understand effectively what all this means in some layman's terms. Now, I am strongly disposed to do that, and it is those matters that I want to raise with you. Now, Mr. Holdenson, do you wish to say anything to the topics I've addressed to this point? Or Mr. Wood?
Mr. Wood will address those matters, Your Honour.
Thank you.
Thank you, Your Honour. First of all, thank you for identifying that list of issues. Can I say at the outset that I do seek leave on behalf of my client, Novak Djokovic, to orally apply for relief with respect to the purported decision of the Minister under Section 133C, sub 3 of the Migration Act, to cancel Mr. Djokovic's visa.
Yes.
I would seek the usual relief, including certiorari and an injunction restraining removal and a mandatory order requiring his release from immigration and detention, the same relief that was sought in the earlier proceeding. Your Honour, in that respect, I also, on behalf of Mr. Djokovic, make the undertaking to file a formal written application as soon as reasonably practicable. And indeed, we are a little bit more ambitious, I think, than what Your Honour had in mind on timing. We, Your Honour, think that we will be in a position to file a formal written application by 10:15 p.m. tonight.
I'm grateful for that indication. Before you continue, on an assumption that a transfer order is made, and I can do that of my own initiative, as I have indicated, that order would become operative upon it being confirmed pursuant to Section 32AD of the Federal Circuit Court of Australia, Federal Court of Australia Act, I beg your pardon. It is not for this court, as I've emphasised, to purport to direct in any way, shape or form how the business of the Federal Court of Australia should be conducted. But if one tries to think about this in a practical, efficient way that is consistent with the parties and obligations, their overarching obligations to themselves, each other and this court, it is difficult to imagine that any judge to whom a proceeding is transferred, that is of this kind, would not themselves immediately turn their mind to what orders they contend to be appropriate for the determination of the proceeding by them in their docket. So I'm certainly content to make orders which are driven to the aspiration that you've expressed of 10:15, and I'm sure that would be consistent with some of the matters that have been dealt with under the heading sensitivity in the submission.
But Your Honour, would Your Honour hear me on the anterior question of whether Your Honour ought to, I understand that Your Honour has the power. Can I make a brief submission directed to the question of whether Your Honour ought, in the exercise of discretion, transfer the matter to the Federal Court?
Of course you may.
Very briefly, Your Honour, the only concern we have with that course of action is what we perceive would be chewing up of time that is, in the extraordinary circumstances that my client finds himself in, extremely precious every minute that we have before the tournament commences on Monday. There are at least two steps of the process that we apprehend might cause delay and perhaps unnecessarily so. First of all, as Your Honour had indicated, the Federal Court would need to confirm the transfer. I don't myself doubt that the Federal Court would think it fit to do so, but it's a process and a hurdle that we think is not necessary in the urgent circumstances of the case to create that hurdle to be cleared. Secondly, in any event, Your Honour, we appear before Your Honour now at 9:15 on Friday night. As Your Honour was indicating a moment ago, whichever judge of the Federal Court of Australia who was to preside in any proceeding transferred to it would need to contemplate their own procedural directions they think appropriate. Your Honour, we come to you right now, having had these reasons for decision for approximately now 3 hours with a proposed timetable. If Your Honour were minded to retain the matter in this court, we would make submissions to Your Honour about what that timetable would be, and we would therefore avoid the need for appearance at a different judge on a future occasion about those matters and uncertainty in the meantime as to how the matter is going to progress in the very limited time available. To the extent, Your Honour, that there is any concern underlying the contemplation of transfer with any question of apprehended bias, I don't know if that is a concern of Your Honour. It's certainly not a concern that we think ought apply. Your Honour, on Monday, in accordance with agreement of the parties, granted relief on a singular basis concerned merely with what one might call a procedural question, the reasonableness or otherwise of the conduct of the delegate's interview. It is impossible in our submission, Your Honour, to see how any reasonable bystander might think that Your Honour's adjudication on that point could possibly have any bearing on the issues which we intend to agitate concerning the legality of an entirely separate process, being one that has culminated this evening in a decision of the Minister personally to cancel my client's visa. So, Your Honour, there's a number of other things I might say about questions about injunctions bearing on removal, questions about orders about form and location of detention in the meantime, and of course timetabling. But I did want to make those submissions about the possibility of transfer, Your Honour, lest there be a possibility Your Honour would be persuaded to keep the matter.
Before moving further, do you have a precise understanding whether the applicant has already been retaken back into detention?
He has not. Can I add to that further, Your Honour, so to try to complete the picture as much as I understand it? I understand that a lawyer, not Mr. Lloyd, but a solicitor from the Australian Government solicitor has advised that it is not proposed, as I understand it, by the Minister to re-detain my client tonight. Your Honour has obviously heard or read, perhaps, of the prospect of the suggestion that my client might be required to attend at a location at 8 a.m. tomorrow morning. That question is one that I would address. We would seek, Your Honour, a version of the same kind of order that Your Honour made the other day that would facilitate my client being together with his legal team tomorrow to assist in the preparation for the hearing.
That was the order I made on Sunday night, wasn't it?
It was Sunday night last week, Your Honour, yes. And so what we had in mind, I can address Your Honour on the formulation of orders, but in substance what we had in mind is this, Your Honour. It moves a little bit to speaking of timetabling, but in substance what I had in mind was that if Your Honour might make an order, or perhaps the Minister might make an undertaking if he is willing, that my client would be permitted to be located with his legal team during the day tomorrow, and that just as I understand the Minister is not proposing to detain my client tonight, and that my client will therefore stay at his present residential address tonight, that my submission would be it would be somewhat absurd for the situation to be any different on the Saturday night. Where this is leading, Your Honour, in terms of timetabling is that I can step out what we had in mind about timetabling, but I'm aware of the anterior question about transfer. But what we had in mind, Your Honour, is that we would be in a position not only to file an originating application tonight, we would expect to file final submissions by midday tomorrow. We have at least one particular ground in mind, we are considering, obviously, others. So we would file an originating application tonight in a formal sense. We would file submissions by midday tomorrow. We would expect the Minister to file submissions by, we suggest, 10 p.m. tomorrow. The matter would then be ready for hearing subject to the convenience of the court on Sunday, if that were suitable. Your Honour, in terms of oral submissions, this will be a hearing, as I appreciate sitting here now, that will be much more confined. It will be simpler. The grounds will be narrower. I have no expectation that oral submissions would need to take any more than 60 minutes. They may well be substantially less. And we would be happy to sign up to a strict limit of the kind that Your Honour made the other day, but an even shorter period, 60 minutes, for example. We hope that the matter, we understand the court is under considerable pressure. I don't want to add to that. All I can say, obviously, is that as things stand, Mr. Djokovic may be scheduled to play on either Monday night or Tuesday night. The precise night might become clearer the further we go on in time, but as things stand, that's what we understand the position is. And in those circumstances, we're very concerned about time. Can I say one more thing about time? I don't wish to be critical, but the position we find ourselves in today is the product of being given reasons for decision and decision material shortly after 6 p.m. on a Friday, more than 4 days after the original decision was made. To the extent that media commentary may suggest that the Minister was burdened by material that we were providing, the reasons for decision record, Your Honour, at paragraph 13, that the only substantial material provided, the only what might be aptly described as a voluminous material, which was a set of scholarly articles about the consequences of recent infection. Natural immunity were expressly not read by the Minister. He says that in paragraph 13. The advice that the Minister received from the Department of Health is recorded as having been received on Tuesday the 11th. We are where we are because of the time the Minister has taken. We are moving as fast as we possibly can. We wish the litigation to have a purpose. We hope that the court, whether it be this court or the federal court, would be in a position to hear the matter on Sunday and determine it at a time that, if my client is successful, he would be in a position where he would be able to play on Monday night. If that indeed is the way the schedule plays out. And it's that concern, Your Honour, about timing and scheduling, which drives really my submissions about transfer. We hope that there can be as few impediments to the quickest determination of what we expect to be a fairly simple application over the course of the next period of time.
So, Mr. Wood, to break this up a little, as is so commonly the case in applications for judicial review in relation to decisions made under the Migration Act, including with respect to the cancellation of a visa and including with respect to the process by which the decision was arrived at. In so many cases, there is really no contest on the evidence. The parties put in a court book, or they put in an affidavit. The minister may put in some brief affidavit that seeks to correct the odd fact here or there, but it would be absurd for me to suggest with the council representing both the minister and the applicant in this case that they do not very, very well understand the nature of judicial review and the very limited nature of the jurisdiction which this court has to quash a decision which requires in substance that a jurisdictional error is demonstrated and that the error is demonstrated to be material such that the court is persuaded to exercise its discretion to grant relief of the kind you foreshadowed. Now, do you apprehend at any level at all I'm not tying you to this. Can you see any reason why the evidence in this case could not be as confined as I've described it, or whether there is any tendentious issue that separates the parties?
No, Your Honour. I don't presently expect that there will be evidence beyond the reasons which will be critical and the submission, including the annexures that were provided to the Minister. There may well be debate, Your Honour, about the inferences to be drawn from reasons, but that is typical and
it's always the case. It's always the case.
Not only do I not expect there to be cross-examinations, subpoenas, anything of that kind, Your Honour, but as I sit here now and we expect that the nature of the legal grounds that we are presently formulating will be simpler and fewer than those that were agitated with respect to the first purported decision. I am quite confident where I sit now that this will be a matter that can be prepared quickly and heard and determined quickly.
Mr. Wood, you've touched a couple of times now upon how narrow the ground or grounds will be in contrast with what was to occur on the last occasion. Are you able, even in the most general terms and without confining you to this description at any point in the future, simply to inform the court what the intended or currently proposed ground of challenge is to be?
Certainly, Your Honour. There is one, and I'll call this for the sake of discussion ground one. We, of course, are contemplating actively whether there are other points we wish to agitate. But let me articulate what I expect to be a central feature of our case. Has Your Honour, and I'll keep this brief, but just so Your Honour understands, has Your Honour had the opportunity to read even briefly the reasons of the Minister?
The most exaggerated answer I can give is slightly.
Yes. Well, let me put it this way, Your Honour. The reasons of the Minister stand in stark contrast to the reasons that were promulgated by the delegate at the airport. In substance, and without pretending to be getting this perfectly right, the delegate at the airport was saying, Mr. Djokovic, he may infect other people because he's not vaccinated. The present set of reasons is starkly different. Let me explain why, Your Honour. In the present case, what the Minister does is, in substance, to assume in Mr. Djokovic's favour every single fact, if you like, that might have been an issue previously. So it's the Minister finds or assumes that Mr. Djokovic has in all respect complied with the law. That's paragraphs 15 and 45. Importantly, the Minister finds or assumes that Mr. Djokovic poses only a negligible risk to others by virtue of, in effect, having natural immunity from recent infection, paragraph 13. The Minister finds or assumes in Mr. Djokovic's favour that, moreover, Mr. Djokovic has a, quote, medical reason for not being vaccinated. The Minister finds that Mr. Djokovic is of good standing, and it's trite that Mr. Djokovic is in a nutshell, Your Honour, is this. The Minister was making a binary decision. If he did not cancel Mr. Djokovic's visa, then Mr. Djokovic, subject to the possibility of a further decision being made, stays in Melbourne, plays in the Australian Open. It's present here, and whatever, in terms of what excitement that may lead to in the anti-vax community, that would be the case. The binary alternative is that the Minister cancels Mr. Djokovic's visa. That cancellation leads to the forcible mandatory removal of this man of good standing who has a medical contraindication to a vaccine, who's complied with law, who poses a negligible risk to others, being forced out of Australia and being subject to provisions in the Act and the regulations that would then preclude him from coming back to Australia for 3 years, subject to the possibility of a waiver being exercised. That was a simple legal proposition, the binary alternative. And that's the path the Minister's gone down. What seems to us, Your Honour, at the moment, as presently advised, but we are considering it in detail, is that the clear jurisdictional error of the Minister is this, and it might be explained as irrationality. The Minister only considers the potential for exciting anti-vax sentiment in the event that he's present. But the binary alternative of forcibly removing this high-profile, legally compliant, negligible risk, medical contraindication player, precluding or impairing his ability to come back to Australia for 3 years and prejudicing his career, on the basis of 2 statements made in 2020 and the possible perception of those statements by others, the Minister gives no consideration whatsoever to what effect that may have on anti-vax sentiment and indeed on public order. And we say, Your Honour, as we presently sit here, that seems patently irrational. When there are only 2 binary options and the minister only addresses the potential anti-vax sentiment excitement on one, but not on the other, he has no rational basis to say that the decision that he then makes is one which is apt to generate unacceptable or greater amount of anti-vax sentiment that clearly he's trying to minimise. That's the point, Your Honour. It's quite simple. Now, there are a range of other matters that we are obviously giving active consideration to. There is a, this is not complete. There is a finding at 22 Roman 2 for which there is simply no evidence. So at 22.2, the minister relevantly says that there are, quote, media reports that some groups opposed to vaccination have supported Mr Djokovic's presence in Australia by reference to his unvaccinated status. Attachments K and L are referred to. In the time we've had available, there is no reference whatsoever in either of those media reports to Mr Djokovic or his supposed position on vaccination. And indeed, the vast bulk of the events to which those media reports and so forth relate happened in December 2020 and earlier, before Mr Djokovic had even arrived in Australia. So there doesn't seem to be any evidence for that positive finding. There is at least one further point that we are reflecting on, which is, if you're and I can take Your Honour back to paragraph 18. It's paragraph 18, bear with me. All right, but look, I think I've probably given Your Honour enough flavour of the 2 points I've mentioned. Mr Hartley rightly probably tells me we need to think a bit more carefully about other points, but we at least have those. So, Your Honour, just reflecting, and I appreciate Your Honour's been hearing this from me orally, it hasn't been assisted by documents, and indeed hasn't had a real opportunity yet to digest the Minister's reasons. But I think Your Honour would have heard enough to appreciate that that first point that I've discussed is not complicated. It's simple. That's not to say we are supposing we will succeed, but it is a question largely of inferences to be drawn from the Minister's reasons and questions of essentially rationality and perversity in the approach to decision-making. I hope that assists Your Honour on the grounds that we're contemplating.
Thank you. Anything further?
I would have things to say, Your Honour, about removal, detention, and I've indicated timetabling, but I think to some extent those matters may depend on the question of transfer that I've addressed.
Mr Lloyd.
Thank you, Your Honour. In relation to the points you raised, taking them in order, we obviously have no issue with my friends making an oral application or relying upon documents before they're in an affidavit for the purposes of the oral application. In relation to the point of a transfer, my client doesn't oppose it. We're not asking for it either, but we don't oppose it.
Thank you.
In terms of my friend's proposal that they could, in effect, prepare their case by midday tomorrow and we would have till 10 p.m. tomorrow, we would be able to accommodate that.
Thank you.
With a view to a hearing on Sunday morning. In relation to the question of removal, my client is prepared to undertake not to remove until the end of these proceedings, but before Your Honour, or if transferred before the federal court.
Did I understand you correctly to mean wherever the substantive proceeding is determined, your undertaking would operate?
That's so.
Thank you.
And then on the question of detention, as I understand, there's been some discussion, I don't know between who and who, but...
Yeah, look, Mr Lloyd, I think you and Mr Wood have been careful to try to avoid trenching on ground which is not the subject of any evidence before me. And given the undertaking to which you've referred, and I should perhaps, if it's possible to draw an inference from it, given the way in which the parties have conducted themselves to this point, I would be most reluctant until the position is clarified to be asked to make any sort of determination about detention. Do you want to say anything about it?
I don't even think my friend has asked you to make anything about determination. Maybe he will come to, but I didn't understand him to. I was just going to say that there has been some agreement, as I understand it, that Mr. Djokovic will not be detained will not be detained tonight on the condition that he attends my client's offices in Lonsdale Street at 8 a.m. tomorrow morning.
Can I ask this question, Mr. Lloyd, just so that we are sure that we're considering this issue from the same perspectives? A matter raised by Mr. Wood, as I understood him to describe the type of relief to be sought in the originating application once filed, he described quite understandably as being framed in the orthodox terms for certiorari and so forth. And he added that he would be seeking an order against or in respect of detention. But when he said it, so there's no doubt, as I understood him, he was conveying that that interim relief would be included in the application on an assumption that it would become the subject of an application if detention became a live issue. That was put perhaps a little unclearly, but I hope you have the gist of what at least I understand is being suggested.
I had understood my friend was saying that his relief would be for a final injunction for release from detention. And obviously, if they're successful, we understand that. I don't understand that they're applying for any interlocutory injunction for release from detention, and I don't think they can.
No, thank you. And that was the PowerPoint, if I can describe it that way. I was worried about what might occur, and if it's only final relief, then it is.
So all I was explaining is that my understanding of the arrangements are that Mr. Djokovic should attend our offices at 8 a.m. tomorrow, and he wouldn't be detained before then, and that if there's to be a hearing, he would be brought to his solicitor's offices for the purposes of the hearing, and under the Act, and I have no reason to believe this wouldn't be the case, there's a requirement to ensure that access to lawyers in some suitable form is required. It has to be provided when you're in detention. So he should have access to his lawyers even if he is detained at 8 a.m. tomorrow. So I suppose the only issue is in relation to that. But so far, my friend hasn't made any application in that regard. He's just said what he would like, and we're saying that what we understand will happen is that Mr. Djokovic will attend our offices at 8 a.m. tomorrow, and those officers will do what they do in relation to detention, but will comply with the Act as they are required to do in relation to access to lawyers. I'm not sure, in terms of, I think my friend might have mentioned in passing time limits. I mean, if their case is only going to take an hour, I'm sure we will finish within the day, but we're not attracted to predetermined time limits before we even know what the grounds are. So we would oppose that if there's any suggestion of that. But if their case is roughly an hour-long case, I don't imagine there would be a problem in it finishing, reasonably tidily.
Thank you very much, Mr. Lloyd.
Thank you.
Can I ask a question?
Certainly.
On Monday, Mr. Tran quite properly drew to the court's attention the availability of the discretionary power under section 133C. And the text of paragraph A and paragraph B, at least at first sight, well, not at first sight, in fact, I identify that the power of cancellation is open to be exercised by the minister, but turns in the first instance upon ministerial satisfaction of the matters in both A and B. You agree with that much?
133
C3.
A, yes, the power arises only if the minister is satisfied of the two matters in A and B.
Yes. It seems unfair to the parties to press them too much in relation to their submissions at this point. Mr. Lloyd, as I understood the challenges being raised in relation to the first decision, beyond the challenge grounded on a denial of procedural fairness, the primary grounds seem to be more directed to the existence of any actual obligation to be vaccinated, and it raises this issue, if you could just think about it in the broadest sense. The expanded guidance provided by the Australian Technical Advisory Group on Immunisation, or ATAGI as this body is known. It's a body established by the Commonwealth Department of Health, and its expanded guidance and its definitions about what fully vaccinated means seems to be the source of the obligation. I think it's important to recognise that that issue was never determined on Monday, and the other side of this coin seems to be that on the whole of the material, the documents to which the court's attention was taken on Monday, as is so often the structure of legislation or regulations, you begin with a general rule and then you admit of the possibility of exceptions. So that the case as I had understood it was the general rule was an obligation to be vaccinated, an exception was medical exemption. So there seems to be some confusion still necessary to be addressed in this case for the purposes of appreciating whether there was a correct understanding of the applicable principles. Stated in other terms, it was never the applicant's case that he was vaccinated. His only case was he fell within an exception. So if there was an exception and if he had an Australian travel declaration which had been assessed and given the green light, that part of the case I think remains unresolved. But that case is over. And a further aspect of this that I need to raise for both of the parties is if you begin from a position that this ATAGI expanded guidance is a matter the status of which has to be ascertained, I know it's probably completely obvious to you, but I feel obliged to point it out to all parties. Probably because if I'm to take judicial notice of it, I have to tell you about it.
Sorry.
I'll just finish because the last thing I wish to say. It seems to me the court is entitled to take judicial notice of the fact that the outbreak of this COVID pandemic has had a very, very significant impact worldwide and in Australia, including in particular on the Australian economy, including in particular on its peoples, including in particular on their livelihoods and their physical and mental health, and that all of these matters are matters for government policy. And I just wonder whether this is effectively an important foundational aspect of this case.
Well, can I say, in respect of that, I mean, obviously, as Your Honour will know, I wasn't in the matter on Monday, but that matter was a cancellation, which, as Your Honour knows, was set aside. That decision is over. In fact, that entire matter is over. This is an entirely fresh application and a new.
I have said that.
And the Minister has, I would agree with Mr Wood, at least to this extent, that the Minister has his own reasons for his decision, and Your Honour will be asked to consider the validity of those reasons, and they won't turn on the same issues as the earlier case, because they are posed differently, and they're not, the same issues don't arise.
Thank you, Mr Lloyd. Mr Wood, anything further?
Only just two brief points, Your Honour. So for on that Atagi point, to explain how it doesn't arise here, Your Honour, if you take paragraph 15 of the Minister's reasons, consistent with what I was saying earlier about the Minister's radical new approach, where all the issues that mattered to Monday's hearing no longer matter. So at 15, dealing with Atagi, the Minister says, I will assume that Mr Djokovic entered Australia consistently with Atagi documents. I'm aware there was a dispute about this in the Federal Circuit Court in relation to the delegate's decision. For present purposes, I'll assume that Mr Djokovic's position is correct, rather than seek to get to the bottom of this here. So in other words, in substance, the Minister says consistently with a broader approach, assume that Mr Djokovic did tick every box, that he was exempt, that he poses no risk of infection himself to others and so forth and so on. That there was no problem with declarations and the like. The underlying new rationale is not a direct risk to others. It's that Mr Djokovic being in Australia, in Melbourne in particular, by being here, will excite anti-vax sentiment. That's the point. Radically different approach. Now, on the only other matter I wanted to mention, Your Honour, is just to be clear about the detention point. Yes, we are seeking, by way of FANA relief, an order for immigration detention. No, and I agree with Mr Lloyd, I can't tentatively ask Your Honour to order that Mr Djokovic be released in the community pending the determination of the case. I accept that the Minister has purported to cancel his visa, and an officer could therefore reasonably suspect that he's an unlawful non-citizen and thereby detain him under 189. Of course, we say the decision is affected by jurisdictional error, but I don't say that undermines the capacity of an officer to reasonably suspect that he's unlawful and therefore detain him. The point, however, is that immigration detention in the Act is a flexible concept, as Mr Lloyd knows, and indeed, when Mr Djokovic attended my solicitor's offices at the hearing on Monday, he was, despite being here rather than in the Park Hotel, in immigration detention. He was in immigration detention because there were ADF officers in the building, ensuring that he didn't leave the building. Now, all that we say about detention on an interim basis is that we understand, point one, that the Minister does not propose to detain Mr Djokovic tonight. So the first, and by detain I mean take into held custody. It's contemplated clearly that happened at 8 a.m. tomorrow morning, and indeed Mr Lloyd referred to a particular location in the CBD. The point I wish to make is that, particularly in circumstances where Mr Lloyd acknowledges and is referring to Section 256 of the Migration Act, the right of Mr Djokovic for access to his lawyers. And point two, if it's the case that this court or the federal court will hear this matter on Sunday, as both parties, I think, now contemplate.
More accurately, hope.
And in light of the significant practical difficulties that we encountered while Mr. Djokovic was at the Park Hotel and getting instructions from him previously, we do think it would be appropriate for the court to make an order that not only ensures that Mr. Djokovic can be detained with us during the hearing on Sunday, if that's when it occurs, but that indeed, given that there will be 1 day preparing for that hearing being tomorrow, that Mr. Djokovic could also be detained with his lawyers tomorrow, rather than going through the somewhat pointless process of being detained with a potential media circus at 8 a.m, taken to some unknown location, only then to be brought back within 24 hours, potentially for another hearing. It all seems rather more kerfuffle than is necessary or appropriate, particularly when the Minister doesn't propose to detain Mr. Djokovic tonight. So there seems to have been some accommodation by the Minister. We're not quite sure why that wouldn't extend to sensible accommodation tomorrow.
Sunday.
And into Sunday, obviously. So tomorrow during the day at specified location where the lawyers will be. Tomorrow night, we see no reason why that wouldn't be the same regime as tonight. Sunday, with his lawyers at the hearing.
Opposed, Mr. Lloyd.
I'll just look at some instructions I've received.
I hope so.
The proposal that my client has suggested is that arrangement could be that he would, as previously agreed, attend at the department offices at 8 a.m, where he would be detained. Then 2 ABF officers would attend at the solicitor's offices with him, sitting on the same floor but away from his conference room during that day. That would make him still in detention, I assume, is the premise. And then he would leave the offices tomorrow. What it says here is after midday, and then be taken back into detention.
And thereafter, your client would be adhering to its earlier stated position that the applicant would also be present at the offices of his solicitors on Sunday if a hearing was held on that date.
Yes.
Oh, I'm clear about it. No detention tonight or overnight. 8 a.m. at the offices of your client, detained. Then from some time after 8 a.m, in detention at the offices of the applicant's solicitors, being effected by 2 members of the Australian Border Force being present on the same floor where he is providing instructions for the purposes of a hearing on the Sunday. And thirdly, back into detention on Saturday night. And finally, in detention at the offices of his solicitors during the course of the hearing, if that was possible.
Yes, although I perhaps indicate that the current instructions I have is that he'd be taken to his solicitor's office to assist them to prepare their submissions up until midday, and then he'd be taken back into detention thereafter and for Saturday night. And then brought back to his solicitor's offices on the Sunday morning for the hearing, assuming there is to be a hearing on Sunday.
Well, the position that obtains, as I've understood it, Mr. Lloyd, is that Mr. Wood cannot, to adopt his expression, tenably contend that I can do much else about this. It's really the concessions that are being made have been made, and other than that, the Act applies.
Well, I understand what my friend has asked for. I think we've come a long way to give him what he wants, but unless there's some other proposal, I mean, that's what my client is prepared to agree to.
Well, it is not in any sense intended to be any sort of criticism of the respondent. The fact of the matter is that the Act contains the provisions it does, and it imposes affirmative obligations once a cancellation decision has been effected. I don't need to say anything more to the parties present about what the Act requires to happen. So you would say, as you have said more than once now, my client has made a number of concessions. It may not be exactly what the applicant wants, but it's a lot more than might otherwise have been proffered. The court will adjourn briefly.
The Federal Circuit and Family Court of Australia stands temporarily adjourned.